Hello, and welcome to Mink Law Defamation News, where I speed through this week's top stories in defamation. I'm Cassandra Harner, and I am not a lawyer. I just work here. In the ongoing defamation case against Representative Nancy Mace, the legal focus is on whether her statements are protected by congressional immunity.
These men aren't just criminals. They are predators.
Her statements made during a House floor speech and on social media may be protected because they were made in the context of her official duties as a congresswoman. The Department of Justice has intervened, citing the Westfall Act, to argue that Mace's House floor speech and related social media posts fall within her official duties. If the DOJ's intervention is successful, the federal government would replace Mace as the defendant. This means that any financial liability, such as damages awarded, would be covered by the government, effectively shifting the burden to taxpayers. The plaintiff's team opposes this, arguing that Mace's social media posts are personal attacks. The court has yet to rule on whether the DOJ can replace Mace as the defendant, leaving the case in a holding pattern. The outcome will set a precedent on the scope of congressional immunity. Jay-Z's defamation and extortion lawsuit against attorney Tony Buzbee, a partner at the law firm Sheppard Mullin, has been dismissed by a California judge. The case arose after Buzbee represented a woman who accused Jay-Z of sexual assault, leading to a lawsuit that Jay-Z claimed was based on false allegations. The court found no actual malice or illegal extortion, granting Buzbee's anti-SLAPP motion. Anti-SLAPP laws are designed to prevent lawsuits that aim to silence or intimidate someone for exercising their right to free speech. Jay-Z's claims were dismissed due to insufficient evidence of malice, and secretly recorded interviews were ruled inadmissible. Looks like Jay-Z plans to appeal, arguing the court misapplied the law. Meanwhile, Buzbee and Sheppard Mullin are seeking attorney's fees, celebrating the dismissal as a significant legal victory. Former Thai Prime Minister Thaksin Shinawatra is on trial for royal defamation known as lèse-majesté, which involves insulting or defaming the royal family. In Thailand, lèse-majesté laws are strict and can lead to severe penalties, including up to 15 years in prison. This contrasts with the United States, where freedom of speech is broadly protected and defamation laws do not extend these kinds of special protections to public figures like royalty. Thaksin testified in court defending himself and affirming loyalty to the monarchy. A verdict is expected in August 22, 2025. The specific defamatory statements in question stem from remarks Thaksin made to a South Korean media about a decade ago. However, due to the prohibitive nature of lèse-majesté law, the exact comments have not been publicly detailed, which is a bummer considering I like piping hot tea. Speaking of piping hot tea, Representative AOC sparked controversy with a social media post on X that I will always dead name as Twitter, stating, "Wow, who would have thought that electing a rapist would have complicated the release of the Epstein files?" This comment was widely understood to refer to President Donald Trump. This would likely be referencing his civil suit with E. Jean Carroll, which is ongoing, and the updates of this case will be in a different video. AOC's statement led to accusations of defamation and calls for Trump to sue and bankrupt her, citing a previous settlement with ABC News over similar claims. The statement may arguably be defamatory, considering how he has not yet been convicted criminally of rape. But despite public pressure, Trump has not filed a lawsuit against AOC as of now. The debate continues over whether AOC's statement exceeds the protections of free speech. That's all the defamation news I have for you today. If there is a story you want us to cover, comment below and follow us for more updates on high-profile defamation cases.